All right, please unmute everybody. We're already live on YouTube. Just one moment here, please. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Wednesday, September 20th, 2023 at 1:29 p.m. for case 2015-1447 DS, Alexis Tabaka and Christopher Tabaka, Attorney Schaefer for plaintiff and Attorney Elaine for defendant.
Good afternoon to all of you.
Good afternoon, Judge.
Great.
Ms. Elaine, are you ready to proceed?
I am.
And Mr. Schaefer?
Yes.
Okay. Ms. Elaine, do you wish to make a opening statement or proceed to your proofs?
I'll proceed, Your Honor.
Okay, go ahead.
I'll call Chris.
Let me ask Mr. Schaefer if he wants to do an opening statement now or reserve or wait.
I'll reserve, Your Honor.
Okay, thank you. Go ahead, Ms. Elaine.
I call Chris Tabaka, please.
Okay, sir, if you raise your right hand, we'll have you sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do, yes.
Dr. Tabaka, you're my client in this matter, correct?
Correct.
How did you locate me as your attorney?
My wife used you during her divorce proceedings and strongly recommended you.
And you did not hire me at the beginning of your case, did you not?
I did not.
You ultimately switched attorneys from, was it Erica Salerno?
Yes.
And how did you get to Erica?
Erica was a recommendation that we were given. So I had switched to Erica.
Who recommended her to you?
You did, actually.
And why did you switch, just in brief, without talking about anything that might be privileged, but just in brief, why did you switch from Erica to someone else?
Erica was great, but she just stopped. She wasn't as responsive, I guess, as we needed in terms of what was going on.
All right. And do you recall her hourly rate?
Yes, it was $420 an hour.
Did you receive invoices, line item and detailed billing invoices from Ms. Salerno's firm?
I did.
I would propose I would propose Exhibit H as we're defendant's proposed Exhibit H. I would like to present for admission, and let me share my screen. Oh.
You should be able to share. I changed the setting.
All right. Thank you, Jesus.
Mhm.
All right. Do you recognize what I put on my screen as proposed Exhibit H, Dr. Tabaka?
I do.
And what are these?
Invoices from Varnum for her services.
For the record, this is a 13-page exhibit. And are these invoices the ones that you received for Ms. Salerno's work on your matter?
Yes.
Do the invoices include attorney fees that were incurred by you related to the show cause that's the subject of this attorney fee hearing?
They do.
And do they also include fees that were not related to the show cause, but to other matters that she was handling for you?
They do.
And if you estimated the total of all of the invoices that you received, what is the approximate number of the amount of attorney fees that you incurred with Ms. Salerno?
Ms. Salerno's between about $5,000 and $6,000.
All right. And you have not, in this hearing or proceeding, asked for reimbursement of any of these fees. Is that correct?
I have not.
And why is that?
Didn't want to get Erica involved, Ms. Salerno involved in terms of having to come in and testify. Didn't want any, I don't know, overlap, I guess.
Objections to the relevance then, Your Honor, it's not being offered.
I would say that the relevance is to reasonableness of the total fee that he incurred when he is not submitting fees he actually incurred that tips the scales toward the ones he did incur more toward the reasonableness level. And there's been an argument that the fees and time expended on this case weren't reasonable, but actually it's quite a lot more than what we've even presented.
Well, if that purpose, then it's not going to it's going to require me to go into each and every one of these exhibits if it's going to be there for reasonableness.
Okay, well, what I'm going to do is I think it is not appropriate at this point. We're addressing the attorney fees as it relates to these issues. He states it included other matters, so you know, we can address the fees that are contained in Exhibit H, excluding anything else that he might have, any other work or any other issues that he may have been addressing.
All right. So I would move for the admission of H, please.
Okay, Mr. Schaefer?
I object to the H. They're redacted, Your Honor. They're not on their face a determination of the show cause issue that the ruling of the court was at. They're redacted to a point, even the ones that in there as to, you can't make heads or tails as to what it was referencing. And this was a document produced by a third party that is not here. So I don't think the proper foundation is laid. I would need to cross-examine as to what the redactions are.
Well, you can always cross-examine as to that, Mr. Schaefer, but it does, as I reviewed Exhibit H, and I had an opportunity to do that, it does seem that it pertains to these proceedings and the denial of parenting time. And again, Mr. Tabaka has testified that these were the fees that he paid in reference to that. So I will admit it at this particular time and subject to your cross-examination, Mr. Schaefer.
Okay, just for the record, I believe that his testimony was that some of this was not for the show cause, and we don't have any determination of what that is. So I don't.
And again, yeah, Your Honor, we're not admitting it so that anything from these bills are awarded. So it didn't seem pertinent in preparation for this to break out the number. But the point is, the court can flip through it, as it's already indicated, see that some of the charges were for the show cause. It's we're just presenting it for the fact that he paid more than what he's asking for today, and that's it.
Okay. Well, for that purpose, the court will admit it.
Thank you. Dr. Tabaka, did you sign a engagement agreement with my law firm?
I did.
And I will show on my screen what we would propose as Defendant's Exhibit A. Dr. Tabaka, is this the fee agreement that you signed with my law firm?
Yes.
And for the record, this is a 7-page exhibit and I would move for its admission.
Okay, Mr. Schaefer?
No objection.
Okay. Defendant's Exhibit A will be admitted.
Thank you. Dr. Tabaka, have you received periodic invoices from me?
Yes, I have.
Have you reviewed the bill of costs that I submitted in this case?
Yes.
Do the charges on those bill of costs that I submitted in this case correlate with the invoices that you received?
Yes.
And on the invoices you received, those invoices, do they reflect charges for other matters that I'm handling for you other than this show cause proceeding?
Could you say that again, please?
Yes. On the invoices that you've received from my office, were there charges in addition to charges for the show cause?
Yes.
Do the charges on the bill of costs that I submitted include any charges that were on your invoice for proceedings in your case other than the show cause?
I'm going to object at this point in time. I don't know what bill of cost she is referring to. She filed a motion of the strange title of what necessary and reasonable costs. I don't know. It's a bill of cost. A bill of cost normally is under oath, and there was nothing that I received under oath. So I don't know what reference is being made. So I guess I would ask for clarification what bill of cost she's referring.
Okay.
Not a
Ms.
problem. Your Honor.
Elaine, if you could, I note that in your exhibits, you had exhibit B and C. Is that what you're referencing?
It is, Your Honor, and B was attached to what, it was not a motion, it was a statement of necessity.
Well,
and
why, why don't you share the screen and go through with Mr. Tabaka and we can establish that.
Absolutely. Just adjust this size. All right, Dr. Tabaka, I've put on my screen what we are proposing as Defendant's Exhibit B, which is labeled Christopher Tabaka's Bill of Costs for Show Cause Proceeding. Do you recognize this document?
Yes.
And this was a 3-page document, correct?
Mhm.
And this was originally attached to a document we submitted to the court after the court ordered us to produce a bill of costs. Do you recall that?
I do.
And did you incur additional costs related to the show cause after the deadline came and went for us to submit our bill of costs?
I did.
I'm going to now show what we are proposing as Defendant's Exhibit C. And Dr. Tabaka, is this the second bill of costs for the show cause proceeding that we have submitted as an exhibit, proposed exhibit?
Yes.
I would move for the admission of both B and C.
Okay, Mr. Schaefer?
I guess I need to board here, I guess, Dr. Tabaka at the moment.
Well, that's why I didn't put these up at first, because I created them. So I was going to address them in my own testimony.
Well, I guess if it's some created by somebody else. So I guess I would object. The proper foundation is not laid at this point in time.
Well, Ms. Elaine, maybe you can establish, at least for the bill of costs, that that's what he's paid and incurred, so.
Yes, that's where I was headed, and Your Honor
Okay.
asked to put it up on the screen, so I did so.
Okay,
All right. Dr. Tabaka, I was asking you in relation to our proposed B and C, if any of the charges that were included on B and C were charges related to the other matters that I am handling for you. No? Okay, sorry, you broke up a little bit there. For instance, you are also litigating custody in this case, correct?
Correct.
And you are also litigating child support in this case, correct?
We were, yes.
Yes. And do either B or C reflect any of the charges that you incurred for custody or child support purposes?
No.
Do you know, sir, the approximate total amount of lawyer fees and costs that you've been billed by my firm so far in your case for all components of your case?
I guess that's irrelevant, Your Honor.
It is not irrelevant because Mr. Schaefer has made the claim in his objection to my bill of costs that A, I've padded the bill, and B, that I've included fees for things other than the show cause at issue. And so this court may find the fact useful what the total attorney fees are for all matters versus what we have submitted in relation just to the show cause for comparison purposes.
Ms. Elaine, I'll sustain the objection because I'm not really concerned what the total is on other matters, but only as it relates to the show cause on parenting time. I think that's reflected in exhibits B and C, and I think I can look at that as, to make a determination.
I have no problem with that, Your Honor. I was just trying to be responsive to some of the arguments against my bill.
I know, you just don't have to
Okay.
anticipate Mr. Schaefer's arguments.
All right, good enough. Let me see where I left off here then. All right, Dr. Tabaka, have you also paid some expenses that were not included in our bill of costs that were directly related to the show cause?
Yes, I have.
And do you recall what those expenses were?
Yeah, mainly transcripts from the various proceedings that we've had on this matter.
Transcripts that you paid for directly.
Paid for directly with the transcriptionist, yes.
And have you also attempted to minimize your attorney fees in any way by doing legwork yourself in this case?
As much as possible, yes. Spent a lot of time at the Justice Center the last few months, driving documents there and back and such. Yeah,
Do you maintain frequent contact with me as your attorney
I do.
for purposes of your matter?
Yes,
Do you prepare data or analyses and summaries of materials that you expect for me to review?
I do.
And would you say that the materials and thoughts and questions that you reach out to me about are frequent or infrequent?
Frequent.
And do you believe that the communications that we have about and have had about the show cause have been necessary communications?
Yes, absolutely.
Would you say that you spend a little amount of time, a moderate amount of time, or a significant amount of time providing information to me to review and analyze?
Probably a moderate amount of time.
Do you believe that I'm responsive to you?
Yes.
When you have reviewed my billings to you, have you ever questioned a line item on the bill?
I've reviewed them and no, I have not had a question.
Have you ever formed an opinion that the time reflected on my invoices was unreasonable as compared to the work going into your case?
No, it's been extremely fair.
As my client, have my fees seemed reasonable to the case and necessary, reasonable in terms of amount and hours and amount, and then necessary as to the work being done on your matter?
Yes, on both counts, clearly.
I have no further questions. I should have unshared my screen. Here we go.
Okay.
I have no further questions for Dr.
Okay, thank you. Mr. Schaefer?
Could we have, okay, could we have exhibit 1 back shown? Excuse me, exhibit A.
Do you have that, Mr. Schaefer?
I don't have that. I have a copy of it. But I want to cross-examine Dr. DeBaca about it.
Okay. Ms. Elaine, could you share that and put it up for, as Mr. Schaefer doesn't have it?
I can, Your Honor. Can I add to my bill for being Mr. Schaefer's assistant in this court case?
You'll have to take that up with Mr. Schaefer.
I mean, it's almost 4 years into Zoom hearings in the pandemic.
I didn't get the comment. What's the comment? For exhibit, so I'm just asking that it be shown.
I'm unclear why you're not able to do it yourself, but I'm happy to help.
Thank you.
I will note too, actually for the record, and I am going to do this one, but then maybe there's a different approach because I'm taking notes and such during this on my computer. So now I have to manage my computer and use it for showing Mr. Schaefer's exhibit, my exhibits for Mr. Schaefer. So it's not really practical for me to do it. I'm going to do this one and then maybe we can figure out a different way.
Okay, well, maybe we can. I don't know. Mr. Schaefer, have you, Ms. Elaine did disclose those exhibits. Did you make copies or can you have your staff make copies of the others?
I have copies of all the exhibits that she presented
Okay,
in front of me. I need to have the ability to have Dr. DeBaca look at them at the time that I cross-examine.
well, maybe he has copies himself that he could
Well,
look at.
That's fine. The Dr. DeBaca on exhibit 1, this fee agreement covers a limited appearance. Did you understand that for your representation by Ms. Elaine?
Objection relevance.
Okay,
What's
Mr. Schaefer,
objection?
what's
I didn't hear what the objection was.
relevance?
Well, she had him identify this as their agreement, so I need to determine what their agreement was and what the representation was for.
Okay, well, go ahead, Ms. Elaine.
I mean, unless there's a reason that it says it covers parenting time related matters. So unless there's a direction here we're going that's going to invalidate the fees that I charge, I don't see the relevance of having them go through limited appearance and so forth.
Well, that's what I'm trying to do, Your Honor.
Yeah, I'm going to allow you some leeway. Go ahead, Mr. Schaefer.
Do you realize it was a limited appearance for custody and parenting time, related matters, comma, but not child support related matters? Did you understand that?
I see that, yes.
Was that your understanding?
Yes,
And did you enter into this on November 17th of 2022?
I would have to see the date on the document. I don't remember the exact date.
Well, would it be shared up?
Yes.
6 of 7. Did you sign it on that date?
I believe so, yes.
And is that the date that you understand that the representation took place?
Yes,
Okay. And that included the hourly rate that you hired her, is that correct?
correct.
Okay, could we see Exhibit B, please?
I'm gonna need to use my computer for my note taking.
Well, we're a little bit in trouble because Mr. Tabaka doesn't have copies. Mr. Schaefer does, and I don't know how we're going to do it without.
It should be incumbent upon Mr. Schaefer to be able to share his own screen for exhibits and Zoom hearings.
I don't believe that's accurate, not the exhibits.
Well, we could always say it's incumbent on Mr. Tabaka to have copies too. So,
But how's he get? And he has to share his screen?
No, but Mr. Schaefer is just simply doing it for purposes of cross-examination, and your client is the one that doesn't have the copies. So.
I'll continue writing my notes. B is
Thank
on the screen.
Okay, thank you. Could we go to the second page of that, please?
Judge, if you wanted to, I could try to do the screen sharing from here.
Would that work for you, Miss Elaine, if we did it?
I'd very much appreciate it.
Okay.
All right, then please bear with me. I'm not used to doing that. Which one are we looking at again?
Exhibit B.
Okay. All right, one moment, please.
And just so Mr.
Okay.
Schaefer knows, for future reference, we always have the attorneys that if they're doing it, that they do the screen share on the exhibits. So maybe you have to figure that out in the future.
What page exactly are we looking at?
Page 2.
Page 2 of 3.
Okay. Can you
That's correct.
see it? Does it
I
look
can.
good?
Mr. Tabaka, Dr. Tabaka, can you see page 2 of 3?
Yes,
Okay, so you got charged prior to your agreement 1 hour for consultation on November 3. Is that your understanding?
I was charged for 1 hour on November 3rd, yes.
And the next charge is November 16th. And I have a little difficulty of determining what that, you got charged a half hour. What's your understanding that what that half hour is for?
Open file, draft, file and serve appearance of counsel, draft and circulate via DocuSign substitution of counsel, substituting Natalie for Erica, file same with the court.
Okay, and that was prior to you signing any fee agreement, correct?
It appears that was the day before.
Yep. Okay, to November 30th, there was an entry of 30 emails. November 2022, an hour's worth. What emails is that referencing? Do you know?
I believe it's,
I would object just because it sounds like we may be getting into privileged areas. So I don't exactly know what Mr. Schaefer means by what emails, but I think there's a danger of asking him a privileged question.
Well, if it's privileged, then there's a procedure that's available that they be reviewed in camera, but I think I certainly have a right to know what he got charged for and what 30 emails there were.
Well, Mr. Schaefer, I'm going to allow you to go into the emails as they pertain to what matters, but I'm not going to let you get into any work product or privileged communication between the client and the attorney.
Well, I understand that, but if he is saying he should be reimbursed for an hour on that day for 30 emails, I think we need to know whether or not they have to do with this particular matter or something else that he's being represented on.
Well, like I said, you can go into it generally.
Okay, Dr. DeBaca, what 30 emails are being referenced on November 30th?
I believe those are 30 emails that I had with Miss Elaine. I couldn't tell you what specific emails those were. I obviously don't remember that.
Well, are you aware of 30 emails that you had? Did you send her 30 emails in November?
Again, Your Honor, I believe that would be privileged, who sent who emails and what our communications were.
I don't think that's privileged, Your Honor. Maybe the content is, but the fact of the emails aren't.
Well, I'm gonna, again, I guess I'm gonna allow him to go into that. Obviously, if there's a way to determine who sent who the emails, but it won't let him go into the substance of it.
Did you send Miss Elaine 30 emails in November?
I believe that was our emails sent from both sides. So Miss Elaine sending me emails and myself sending her emails.
And did you have email communication with her on other subjects other than the show cause? In November?
November of 22. Was in child custody during that time. Predominant case going on at that time was the show cause. In terms of splitting those emails up, all I can do is tell you is that there was a predominant case going on at that time.
Well, how many emails did you send Miss Elaine in November of 22?
I don't know. Again, those 30 emails are emails sent from one party to the other party, and it could be either. I mean, it's cumulative email communication.
I understand, but my question is, how many did you send?
I don't know.
How many did you receive from her?
I don't know.
Did you send emails to Miss Elaine and receive emails from Miss Elaine on subject matters other than the show cause in November of 22?
Could you say that again, please?
In November of 22, did you send Miss Elaine and did you receive from Miss Elaine emails concerning other matters than the show cause?
Yes, those 30 emails are strictly the ones related to the case at hand. There were actually many more emails than that regarding the other cases as well. This bill of cost is just showing the emails that pertain to the show cause in terms of parenting time.
Well, did you review the 30 emails that were listed on November 30th to assure that they were show cause related?
I did not.
Then how are you able to tell us that those are only show cause emails?
Because there were many more. So if there are 30 listed, then I have to assume those came from the show cause because the rest were for the other matters at hand.
Well,
I did not individually go through and look at each email and add them up to the 30.
Okay, very good. The things that Miss Elaine billed you for on January 4th, you have no personal knowledge other than what she relayed to you as to what time we're involved. Is that correct?
Could you say that again, please?
On January 4th of 2023, there's an entry of review discovery response from Alexis employer. Do you have any personal knowledge as to what she did in that regard?
Yes, this was the subpoena to the county requesting her work hours and correlating those with the parenting time.
Well, that's not what she put down. She put review of discovery. Do you know what she did to review the discovery?
I thought I just answered that. She received discovery and reviewed it in terms of what she received from Alexis's employer.
Well, that's, how do you know that? That's what she told you?
Yes,
Oh, were you there when she did it?
Objection, Your Honor. I mean, this sounds a little, I guess, unreasonable line of questioning in that it's probably common sense that the client isn't over our shoulder when we perform all of our work for the client. So it just seems a little bit unreasonable.
Well,
Mr.
it's
Schaefer?
being entered under Dr. Tabaka's identification, so what choice do I have but to go through each one of these and determine what he knows about it?
You can question me because I'm going to testify.
Maybe that would be an easier way for you to handle it, Mr. Schaefer.
Okay, very well. Let's go up to February of 23. There are 65 emails for February of 23. Do you know personally what those are?
do I know personally what, Mr. Schaefer? You broke up.
Okay, there are listed 65 emails under February 28th of 23 for February of 23, as I take it. Do you know what 65 emails those are?
Those are ones that pertain to, I mean, I assume Ms. Elaine's gonna testify this, but there were far more than 65 emails that month. I can guarantee that. Those are the ones that pertain to the show cause case.
And how do you know that? Did you go through and count 65 emails?
I did
That
not
you-
go through and check Ms. Elaine. I've never had an issue with any of the line items she sent me, so I've never had cause to.
Okay, so you don't know. Okay, fine. Go back to page 1, please. On March 31, there are 42 emails for March of 23. Are you familiar with what 42 emails are being referred to there?
Again, Ms. Elaine bills for emails once a month. I'm sure there were numerous emails. We were in close communication. I don't specifically know which 42 emails those were.
Okay, so your recollection that you sent more than 42 emails in March?
Yes.
And I reference April 30th of 23, there's 28 emails. Do you know what 28 emails those are?
Again, there were more than 28 emails. Those are the ones I assume that pertain to the show cause. And no, oh, go ahead.
On May 31, you were billed for 25 emails. Do you know what 25 emails those were?
They were a portion of the emails sent in the month of May regarding the case and the
So
show cause case.
From your testimony, I take it that you would email or receive emails more than 2 times every day of every month during this time period. Is that consistent with your recollection?
Email is our primary mode of communication, and no, it's not a matter of 2 emails a day. My recollection is we'd go back and forth 5, 10, 15 times on a subject. next week, do something similar, and that's what adds up.
You know, if you got charged per email or on a time basis?
I assume it's on a time basis. I believe Miss Elaine bills according to, I don't know, you have to ask Miss Elaine, I'm not sure.
Well, okay, and did you send emails to the office that were not to Miss Elaine, but to somebody else in the office?
No.
I will save my further cross on those exhibits, Your Honor, for Miss Elaine.
Okay, thank you. Ms. Elaine, do you have any redirect?
I do not.
Okay. Thank you. Next witness, Miss Elaine.
Oh, Mr. Schaefer's finished with that. I'm sorry.
Yes.
I
Yes,
thought,
he's,
I thought
that's
he,
correct, Mr. Schaefer, you are complete on your
Yes, I am.
cross, right? Okay, I
Okay.
thought he was.
okay, I'm sorry. I thought he just meant he was done with that exhibit.
No, no.
I will testify now then.
Okay. Miss Elaine, if you would raise your right hand, we'll have you sworn.
Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
Okay, go ahead.
Thank you, Your Honor. First, with respect to exhibits B and C, which are the bill of costs I submitted, I would proffer those for admission.
Okay. Mr. Schaefer,
I thought you had admitted those already, Your Honor.
we had not admitted them, she had referenced them, but they were not, and
Okay.
we questioned, but they were not admitted.
Okay, well, I will not, with the understanding I get to cross, I don't agree to the being relevant, but as for a reference point, I have no objection.
Okay, then defendants exhibit B and C will be admitted.
Thank you. I will also take this opportunity to testify under oath that the billings reflected on exhibits B and C, the bill of costs related to the show cause, are accurate and correct, with the one exception and a correction I would like to make on the record. That occurs on page 3 of exhibit B with reference to this line item that I'm highlighting on the screen from March 21st of 23. This was erroneous. Part of this was erroneously included because when I ordered transcripts in this matter from Ms. Cox, I ordered a transcript from a hearing that occurred in March of 2022, and then just transferred that inadvertently onto this bill of costs. So the way that the transcript costs were charged to me is as follows. The March 8th, 22 transcript was 74 pages long, and Ms. Cox charged me $2.05 a page. She did not charge me for the March 7th, 2023 transcript. And she did charge $2.05 a page for the March 28th, 2023 transcript, which was 119 pages. So the total pages that should be charged for were just the 119 on this bill of costs. 205 a page is $243.95. So we would reduce our request for costs today. That means a total, it's reduced by $151.70, Your Honor.
Okay,
All right, I'd like to testify a bit to my background in relation to the fee that I charge. I graduated magna cum laude from Thomas M. Cooley Law School with a 3.9 grade point average. After I graduated, I became an adjunct professor for Cooley in a variety of subjects, moot court, scholarly writing. I taught advanced writing for, I believe, 6 or 7 years, maybe more, after I graduated. I was a research attorney starting my career out after law school for the Michigan Court of Appeals. I then became a staff attorney at the Court of Appeals for Judge Stephen Borrello. After my tenure there, I became a staff attorney for Justice Michael F. Kavanaugh at the Michigan Supreme Court and ended up as a senior staff attorney in that office. In my positions at the Court of Appeals and the Michigan Supreme Court, in many of my duties, one of them was writing draft opinions for both the Court of Appeals and the Michigan Supreme Court. I then opened my own law firm in 2007. Since that time, I've become a certified mediator by taking the 40-hour mediation course and 8 hours of domestic violence training. I have received a family law certificate from the Institute of Continuing Legal Education, which involved taking 9 different seminars. I've been named by Lawyers Weekly as one of the top women lawyers in Michigan. I am currently in Super Lawyers, and Super Lawyers names only about 5% of attorneys across the nation as super lawyers to be included in their publication. I focus my practice 100% on family law. I do not take any other subject matter cases. And the reason I do this is that it allows me to devote my entire attention to this one area of practice in order to gain the highest knowledge base possible, which is important to me in serving my clients. I do more than practice family law. I study it regularly. I avail myself of continuing legal education on a very regular basis. I subscribe to the Institute of Continuing Legal Education's partnership program. I contribute materials to that program, which are findable online if you're a member. I've written a variety of materials for ICLE, and I've produced videos also for their publication on their website for training purposes of other attorneys. Every year I attend the 2-day annual Family Law Institute, and I frequently present at that institute as well as a speaker. When I present, I generally spend about 20 to 40 hours preparing the written materials and the oral presentation. I do that for zero compensation because it benefits not only the bar, but also benefits me in that I hone my knowledge in different family law related subject areas quite significantly. I have presented on the area of privilege, child support, evidence, property valuation as a recurring speaker in that subject, the fundamentals of custody, which is one of the family law certificate courses as a recurring speaker on that, parental alienation. I presented on advanced child support strategies. I've presented on marijuana in family law context, bankruptcy in family law context, and I've been on plenary panels with judges across the state of Michigan as well. Changing domicile is another topic matter. Besides presenting to the Family Law Institute, I've presented to the Referees Association of Michigan. I've presented at the Upper Michigan Legal Institute. I've presented to the Michigan Judges Association. And I've been a presenter multiple times at the Family Law State Bar Winter Conference, as well as local bars and other local organizations, women's groups and the like. I currently serve on the Family Law Institute Planning Board with about 15 to 20 other family law attorneys throughout the state of Michigan. I served a 3-year term, which is the top limit on the Family Law Advisory Board for the Institute of Continuing Legal Education. I've also served on the Family Law Section's Court Rules Committee. I spearheaded a family law section committee on the effects of COVID on family law issues at the beginning of this pandemic. I authored the chapter Property Division, which appears in ICLE's 2-volume book, Michigan Family Law, for their 8th edition and their upcoming 9th edition. I've written articles for the Family Law Journal, which is distributed to family law practitioners who are members of the section. I've done additional writing for local bar associations and the like. I also handle family law appeals, making me a more desirable candidate for hiring for family law matters. I went and counted because I didn't know, but I've handled 42 appeals, mostly family law subject matters to the Michigan Court of Appeals and multiple applications for appeal to the Michigan Supreme Court as well. I've actually been qualified as an expert to and testified in an attorney fee hearing in a matter here in Ingham County. So, Your Honor, those are some of my qualifications, and I submit that this background that I outlined qualifies me to be in one of the top percentiles in terms of both ability and billing merit. The Michigan Economics of Law Survey, which I included as attached to my bill of costs and also can offer as Exhibit D here today. May I propose an offer as Exhibit D, the sections of the Economic Law Survey that pertain to me?
Okay, Mr. Schaefer, any response to Exhibit D?
Is he
Well,
fresh?
I guess my first comment is the 2002 economic survey. I'm not sure how relevant it is. It's apparently 3 years old. And I understand that the case law or the appellate law does indicate that the court should review the economics, but I'm not sure it's relevant if it's 3 years old. My only comment.
Okay, Ms. Elaine, any response to that?
Yes, in the Court of Appeals case of Vitiglio, which addressed this exact issue, the Court of Appeals held that the survey is important. It should be referenced. It need not be the only factor the court considers, and it can even go up from the billings listed in the survey. The court recognized that it's only published once every 3 years. That's just a fact. There is nothing else that I'm aware of, at least, that is published more regularly. And I think the age just mitigates in favor, really, of upping a lawyer's fee if all we have to refer to is the 2020 numbers, which is the case here. Then that should just reflect on the fact that, you know, if somebody is asking for higher than an average or higher than a certain percentile, that's probably justified because of inflation purposes.
Okay, Mr. Schaefer, any response?
Well, that is nice speculation, but I guess Your Honor can do with it as it wishes.
Court will admit the defendant's Exhibit D. Obviously, court reviews that repeatedly in cases not only pertaining to family law, but business law cases in which I have to decide fee disputes. And it's regularly recognized by probably most attorneys in the state as the basis for determining the hourly rates for attorneys as it relates to fee disputes. So the court will admit that.
Thank you. I would note that for an attorney with 20 years experience like myself, the 75th percentile listed in the 2020 version is $367 an hour, while $546 is the hourly rate for an attorney in the 95th percentile. An attorney practicing in the Lansing area, which of course I do, the 75th percentile rate is $345 an hour, and the 95th percentile rate is $450 an hour. And finally, the billing rate for an attorney practicing in family law is $300 in the 75th percentile and $400 in the 95th percentile. I would also state that as a general rule, I bill conservatively. I never bill for the time I spend laying awake at night thinking about, worrying about, and strategizing about the cases while I lose sleep. I don't charge a surcharge for missing time with my family and other events and activities because of the demands of a case and so forth. My engagement agreement, Exhibit A, also allows me to charge a higher rate for emergency work. And while I did, in fact, have to put down other work in this case to tend to urgent issues that arose, I have never invoked that higher fee that my contract says is warranted. I'm going to put up a portion of Exhibit A, my fee agreement now, for explanatory purposes. All right, and I would direct the court's attention to paragraph 17 with respect to email. And it essentially explains the way that our firm bills email. stating that 1/10 of an hour is a minimum billing on any item, including individual emails. However, in our discretion, we can bill less than that minimum for short emails. But all emails pertaining to the client's case, including the firm's internal emails, will be billed. And that the firm may also group all emails sent and received within a specified amount of time and bill the same amount of time for each email. And the amount of time to bill per email may change from billing cycle to billing cycle if we believe a change is warranted. So through many years of trial and error and practice in billing, this is what we arrived at, made the most sense for both the firm and the client in terms of email billing, because what we were attempting to do there is limit a client's exposure, because in a month where there are, let's say, 100 emails, if we build the minimum of 0.1 for that, that would be an extraordinary amount that the client was paying. So what we do is count them all up and bill them in bulk at a much lower rate than that. With respect to the emails billed on my bill of costs, I will note for comparison purposes that, oh, first of all, I will testify, Your Honor, that I went through the emails, and it was not a fun or fast exercise. And I counted up the ones that were built that were related to the show cause. So there were more emails than were reflected on my bill of costs, and the full number of emails was reflected on the invoices that Dr. Tabaka received. And I'm going to tell you what those numbers were. For instance, in November of 22, emails billed to Dr. Tabaka were 50. And on my bill of costs, I listed 30 because there were 20 that were not related to the show cause. In December of 22, the number on the bill of costs, I can't recall. Let me just check that really quickly. 22. No emails were billed on the bill of costs, but I had, I think, only 3 in December billed to Dr. Tabaka. In January, all of them, the 42, were all related to the show cause. And again, these were not all emails from Dr. Tabaka to me or me to him or between us. There are emails that we bill for all emails, as my fee agreement said. So communication with Mr. Schaefer, communication with Mr. Schaefer's assistant, communication with the judge's office, the clerk's office, court reporters, the mediator, subpoena related, for instance, counsel for Calhoun County Sheriff's Office, everything that is related to the case. In February of 2023, Dr. Tabaka was billed for 237 emails, but on the bill of costs, only 65 are listed because those were the 65 I determined related to the show cause. In March of 2023, he was billed for 109 emails. The bill of costs reflects 42 that were related to the show cause. In April of 23, I billed him for 64 emails. Only 28 of those are reflected in my bill of costs as related to the show cause. And for May of 2023, there were 102 emails billed and only 25 listed in the bill of costs. While the show cause droned on, in June of 2023, there were 119 total emails. I didn't even bother putting any on for the second bill of costs. Same for July, where there were 95 emails, and August, where there were 236 emails. With respect to the work that I put into the show cause hearing itself, I would just make a few comments. First of all, there was a lot of preparation work. One of the critiques that Mr. Schaefer has of my bill of costs is that I guess I worked too hard or too long or too much, which is an interesting observation. But in any event, it isn't true that I worked too much or too long or too hard on Dr. Tabaka's case. I put in the work that was necessary to handle the matter at hand. For instance, I spent time because I required my client to provide me with the entire Our Family Wizard history, which is important to review before going into a hearing at which communications are going to be at issue, and they were in this case. That was a total of 444 pages. We had multiple discovery responses from the Calhoun County Sheriff's Office, which totaled hundreds of pages that I had to go through and digest. Dr. Tabaka actually saved hours of attorney fees by doing the initial analysis of timesheets from Ms. Tabaka's employer, so that fees for my time, that initial crack at that information were not incurred. But I estimate that would have added 10 to 20 hours probably to my time. There were 20 exhibits that I curated, prepared, and were ready for the hearing. I don't remember how many were admitted, but there were 20 that were curated and submitted as potential exhibits. We also had 3 hearing dates in this matter: March 7th, March 28th, and May 12th. As for most cases, I prepared an opening argument. I prepared lengthy questions for the main witnesses in this case. I prepared questions for rebuttal. I prepared a closing argument. You know, in the context of doing all that, we're referencing page numbers of different things like transcripts, exhibit references, cross-referencing, all sorts of things. A lot of work goes into that. Your Honor, having been in private practice, you're well aware of this. With respect to the costs, I already talked about the transcript cost, but I will just mention too, there was a mediation cost. Mr. Schaefer commented that I didn't produce a receipt for that or something of that nature. I don't have a receipt from Mr. Brundage. I paid that by credit card, and Mr. Schaefer presumably paid the exact same amount that Mr. Brundage required both of us to pay, which was $500. And then he refunded me, I believe it was $60, which is listed on. So the total mediation cost was $440. Let's see. Opposing counsel made in his objection an allegation which I found quite frankly a little bit unprofessional, which occurs on page 3 of his objection. It states as follows: "It appears that after the ruling of the court, this is a prime example of padding the bill in order to bring the matter up to an area that defendant wants to take advantage of the formula that is set forth by the judge." Well, since my billing was contemporaneous, which it was, it is impossible for me to have padded my bill to take advantage of the court ruling. And I believe what Mr. Schaefer is referring to there is that this court only awarded half of the attorney fees because it determined that we didn't get the full relief we were requesting, so we would only get half the attorney fees. Well, I didn't know that until May 12th of 2023. So I couldn't have been pre-padding my bill and anticipating such a ruling. So I just wanted to dispel the specious claim that I in any way altered or increased my fees in this matter from what I had already recorded and already charged to my client. Your Honor, unless the court would like me to address any other particular item, I believe that that concludes my testimony.
Okay, thank you. So just to, if you could, just to clarify on the correction that you made as it related to the transcript, you said it's less 151.70. Is that off the 1/2 or off the total? I wanted to.
That's a great question. That would reduce the entire bill by 151. So
Okay.
half
So
of
it'd just be half of that would be okay. That's what when I went through this, I couldn't tell based upon what you testified to.
All right.
Okay. Mr. Schaefer, any cross-examination?
Yes. Ms. Helene, in relation to your exhibit into the economic.
Oh, yes. Go ahead.
Excuse me?
You cut out, but I heard you now. Go ahead, please. Sorry.
Oh, okay. All right. Very good. On the economic charts and surveys, the community that you are practicing in this particular matter is Calhoun County, Battle Creek, correct?
Well, I practice in Lansing, Michigan, but this case is in Calhoun.
Yes, correct. And the Battle Creek area on table 6 of your exhibit D indicates that the medium range is 280, 275, mean 375, and 318.95 percentile. Is that correct?
Can you point me to where I didn't look at I didn't look at that because I don't practice there, and the way that the state bar survey.
Okay, no, yeah, you're just answering questions now. You can argue
All right.
later. On table 6 of your exhibit D,
Yes.
okay, the Battle Creek area, will you read across what the percentiles are, please?
For table 6, Battle Creek, 13 attorneys responded. And the rate for the 95th percentile is 318 and the 75th is 300.
And the mean is 275 and the median is 280, correct?
That's what the survey reflects, yes.
Okay, thank you. In relation to table 7 of exhibit D, under family law, the 25th percentile is 200, the median is 250, the mean is 268, the 75th is 300, and the 95th is 400. Is that correct?
That's what the table says, yes.
Thank you. So you have been practicing in private practice since you said 07?
That's correct.
Okay, 07. So you've been at this for 16 years, is that correct?
I believe so.
Okay. Are you presenting anything under the factors of reputation and ability other than your own?
I'm sorry, you cut out at the end.
Okay. You're familiar then with all of your teaching experience and research that under the case law, there's about 8 factors that need to be determined. Is that correct?
There are.
Okay, and you told us about your experience. Are you going to present anything about your reputation or your ability other than your self testimony in that regard?
Well, I believe Dr. Tabaka testified that he hired me because of a referral by another client of mine who I had done good work for, so that she
Okay.
believed.
Well, that's I guess my question is: are you going to present any other evidence other than what you presented and your testimony concerning reputation and ability?
I'm not, no.
Okay. Number 2, the difficulty of the case. Do you consider a show cause as a difficult legal matter?
I think that show causes have elements to them that are not present in like a regular custody motion or child support case. Yes, it involves potential jail time, fines.
Does that make, excuse me, does that make it difficult? A difficult case. It's not a complex case. It's a he said, she said, and whether or not the order has been followed. Is that not true?
I guess the term difficult is somewhat subjective, Mr. Schaefer.
Okay. And the third factor is the amount in question and the results obtained. We're not talking a whole lot of financial issues on the show cause, and the results, you got approximately 60 of what you were asking for. Is that not true?
Again, you're breaking up a little bit, so I heard a lot of your question, but not all of it.
All right, I'll repeat it. In relation to that factor 3 of the amount in question, number 1, we're not talking about a lot of monetary amount in this particular matter, but the results obtained is that you only received about 16% of the makeup time that you had pled in this particular matter. Is that not true?
It is, and I believe that the court.
Okay, thank you.
That when it
All right,
awarded half
all right.
my attorney fee.
Just a minute. I got more questions. And the expenses that you incurred are on your bill of cost. Is that correct?
Yes.
Okay. The nature and length of professional relationship with the client, is this the first time that you had represent Dr. Tabaka?
Yes.
This is the only case that you represented him?
Yes.
Represent any other matter?
Correct.
Okay. Did you turn down other employment because of this case?
Yes.
What did you turn down?
Well, I'm not going to give names of potential clients, but
Well, give me an example.
always, I'm sorry,
Give me an example or a generality of what you turned down.
I will. When a case takes up a lot of my time, I turn down cases. I do it routinely, and I did it throughout this case, and I'm still doing it with this case, quite frankly.
Were there any extreme time limits imposed by the client of the circumstance?
Yes, as a matter of fact, when you didn't submit your exhibits two different times following the court scheduling order, that caused me to have to scramble to deal with late exhibit preparation and preparation with my client pertaining to late exhibits.
Okay. If I suggest to you that the number of emails that you are indicating that you have had with your client, and specifically those involved in the show cause as being extraordinary in a case of a show cause, and I'm suggesting it's extraordinary. Do you agree with me or not?
I do not.
Okay. In these 3 hearings that we had, you had pretty much taken up at least 1.5 to almost 2 of the first hearings by the testimony of your own client. Do you recall that?
Not specifically. I'd have to review the transcript.
All right. Did your client participate in the mediation in good faith trying to resolve this particular matter?
He absolutely did, contrary to the statement you made in your
Okay.
objection.
On your exhibit B as in boy, on February 25, you had 65 emails in apparently the month of February in relation to the show cause. And that's what your testimony is, correct?
And that's billed on February 28th, but yes,
And that covers, as I interpret your billing, covers the month of February. Is that
Correct.
correct?
yes.
And could you tell me to whom those 65 emails were sent or received, or from whom they were received?
Not as we sit here today, but I can testify that they were all related to the show cause because when I prepared my billing of costs, I went back through all of those emails.
That would be an average of over 2 a day, correct?
Well, maybe I got 20 in one day as a back and forth. I mean, it doesn't,
Was your client overly in regard to information and attention of email?
overly what? You're cutting out.
Overly needy? Some clients are more than others. Do you agree with me on that?
I agree. Some clients,
Okay, some need hand holding on a daily basis, some do not, correct?
correct? Yes,
And how would you classify Dr. Tabaka in that regard?
moderate.
And so he would, on a regular basis, if not daily, or multiple times someday, email you with questions, information, is that correct?
Not daily. It hasn't been daily.
Well, then there must have been a lot of days, there were a lot of them if you've got 65 in 1 month.
Well, as I testified, it's not just communications between my client and I, but communications by me and anyone else who I'm communicating with about the case, including your office.
Okay, and how many emails did you bill that you communicated with my office in February?
I'd have to go back and look.
On March 6th of 2023, you billed 3.8 hours of preparation for the hearing.
Yes,
Can you give me some detail as to what you did in 3.8 hours on that particular day?
I object to this question, Your Honor, on the basis of work product privilege.
Okay,
I'm content, Your Honor. It seems like an inordinate amount of time of preparation for a show cause. So if there's some legitimate reason that took up 3.8 hours, I think we're entitled.
well, I think it does obviously go into, again, issues not only privilege, but work product, et cetera. So if she has stated that that all went into the preparation for the show cause, the court is going to accept that testimony.
Thank you.
The day after that, you also spent 2.2 hours in preparation for show, correct?
Yes, and looking back at that, it seems low.
Seems low. Good.
Yes, does.
On March 28th, how long was the hearing that you billed for versus the debriefing of your client?
I'd have to go back and look at the start and finish time on the transcript. I don't know that offhand. And there's also prep for, so there was prep, appearance, and debriefing.
On your exhibit C, you have billed an additional $1,200 for I guess, let me take that back. You billed 4 times for September activity, once in August and 3 June in that billing. Is that correct?
That's true, and it's still going on, Mr. Schaefer, because you have objected.
Okay, just answer the question, please. And did you include any of the other billings that had to do with other entry of orders that were the show cause?
Absolutely not.
No further question, John.
I didn't hear that, Mr. Schaefer. You said nothing else?
Nothing.
Okay, thank you. Ms. Elaine, any additional testimony?
Just a few points based on what I was asked, Your Honor. With respect to table 6, I would note that the table's title is Reported Attorney Hourly Billing Rates by Office Location. And when Mr. Schaefer asked me to read the Battle Creek area line item, but I don't live in Battle Creek, or my office is not in Battle Creek, rather. With regard to the results of this case, I would just comment what this court is already aware of, I believe, which is that no less work needed to go into the show cause proceeding to get a result, right? So the same amount of work would have to go in and the court determines the result. So there was no way to not do as much work because of the result we got, if that makes sense. And I would also further comment that with regard to the difficulty of the case, The case is still ongoing because Mr. Schaefer has again objected to the order
Your
that
Honor,
I.
this is more argument than factual response. I
Well,
believe.
I guess, let me just say that these fees aren't even reflective of the total fees that Dr. Tabaka continues to incur. Thank you.
Okay, thank you. Ms. Elaine, I just to clarify, and basically Exhibit B and C are cumulative, is that correct?
That's correct. So,
Okay.
yes.
I
B
just
was,
want to make sure that, I thought it was because you have the subtotal from first billing and then the other total. I just want to clarify that so there's no dispute.
yes.
Okay, thank you. Anything else, Mr. Schaefer?
Nothing further.
Okay, thank you. Any additional witnesses, Ms. Elaine?
No additional witnesses, sir.
Okay. Mr. Schaefer, any witnesses?
No witnesses, Your Honor.
Okay, so Ms. Elaine, you rest and Mr. Schaefer rest, correct?
That's correct.
Okay, Ms. Elaine, any closing argument?
No, Your Honor.
Okay, Mr. Schaefer?
Yes, Your Honor. We are opposing the inordinate amount of fees that are being asked for this matter. And there's a lot of factors in the case law that goes along with this. The burden is on the petitioner in this particular matter, Ms. Elaine, and her client to determine what attorney fees, and it's the reasonable prevailing in the community, and the community is Calhoun County is the community that the law is being practiced in, and the case law also indicates that the surveys need to be taken into consideration, and certainly that is much lower than what is being charged in this particular matter. We're not in Lansing. We're in Battle Creek, and I don't think you get to take your higher rate and bring it here. The number of hours that were spent and billed are inordinate from the standpoint of emails. In all due respect, I think needy client here that she is placating whatever she has to do to keep him happy, but that is not a reasonable fee for compensation in relation to the judge's ruling. I think there are 8 factors the case law indicates that the court needs and must take into consideration. It must take into consideration all. Number 1 is the experience, reputation, and ability of the lawyer. We have heard nothing on reputation. We have heard nothing on the ability other than the testimony of the lawyer. Experience, most of the experience as he is in the academia and as clerking, that doesn't necessarily mean experience in trying cases. She's been a practicing trial lawyer apparently since 2007, so we got 6 years, which is, I think, middle of the road, and it certainly is not extreme. There are people who have practiced for 50 years, some who have practiced for 5 years, so there's someplace in the middle. Number 2 is the difficulty of the case. This is not a difficult case. This is not a complicated business transaction, not a complicated copyright action, not a complicated PI case. This is a show cause order. It's a he said, she said, applying the facts to an order. So it's not a difficult case. Number 3, the amount in question. Amount, I think, goes to the economic part. There is not an economic part in this. The results obtained. And the results obtained from the motion that they filed is that they got about 16% of what they had asked for. So that is not a high mark on that factor. The expenses incurred are not substantial, and they were listed. Number 5, the nature and length of professional relationship with the client is short. This is the only case she's had with him. So it's not a long-standing client that she's representing. It's somebody new, and this is the first case. Number 6, The turning down of other employment. We don't have any specifics. It was a generality. I suppose that is true with all of us, that if you are going to devote an inordinate amount of time on one client, then you're not going to take other clients. But I think in that regard, this is a needy, and she is taking advantage, if you will, of a needy client by placating to his emails and his need for attention, and she bills for it, which is fine. But that's not a reasonable process to ask for the other side to reimburse that. Number 7, the time limitations imposed by the client circumstances. I don't think there were many at all. This was drawn out over a long period of time and a number of hearings. And the number 8 is whether it's a fixed fee or a contingent fee. And this was obviously a fixed fee. The court needs to determine, according to the case law, the reasonable number of hours needed to be expended for the work done on this particular. I think they are inflated for whatever reason. The amount of preparation time, the amount of billings for emails, the amount of billing for other things, I think are not reasonable in this particular matter to be plugged in. The long and the short of it, I think Your Honor needs to determine what a reasonable amount of hours should be awarded and what the reasonable rate is. I don't think that the $400 an hour rate is the customary rate in Calhoun County. So I think it is closer to $300 an hour. And I think that rather than billing for some 50 hours, and that's what it boils down to, if you've got $400 an hour and you come up with 20 grand, that's 50 hours of billing. I think that's probably 15 hours or more overbilled. So I'm asking the court to figure out a reasonable amount of hours and a reasonable amount of rate that's customary in this community. And so I would ask the court to do that. Thank you.
Okay, thank you. Ms. Lane, you didn't make a closing, but I'll let you
Respond.
address the response. Yes.
I appreciate that. Well, I note that Mr. Schaefer gave a lot of his own thoughts and feelings on the matter, but he presented no evidence or testimony with respect to his claim that my fees were unreasonable or unnecessary in any regard. He presented no testimony, nor was there any evidence that Dr. Tabaka is needy, that I'm taking advantage of him, that I'm placating him, or that I inflated my bill. If he wanted to prove those things to this court, he should have brought an expert to say so. With regard to where I sit in my geographic area, he stated that the case law says that it is what is reasonable in the prevailing community. He didn't cite any case law, but what Victilio says is that the attorney fee is determined on what is reasonable based on all of the circumstances and all of the factors. The survey can be considered, and everything else that is presented to the court must be considered. The geographic area, as reflected in the State Bar Survey, is the one that I'm in, and that's the one they reported fees in. And that's the one I've never left to this very moment, never left the Lansing area to handle this case. I believe that the experience factor is shown by what I recited in my testimony and also what I submitted in my statement of reasonableness and necessity in the cases that I've handled, which were over hundreds. Yeah, so that's what I would say. I would say that my fee is spot on to the survey, which is out of date and should probably be more. My fee is in all the categories but one, less than or in between the 75 and the 95 percentile, which I probably merit easily the 95th percentile. And the only one that it equaled the 95 is family law. And I believe that I warrant that because I specialize in family law. That's all I do. That's all I've done in my practice. And I am frequently called upon to share my knowledge in that subject matter. Thank you, Your Honor. I would ask that you award the fees as stated, other than that minor transcript fee that we.
Thank you.
removed.
Thank you. Well, in this case, the court has heard the testimony, and the court, as Ms. Elaine points out, that the only testimony as it relates to the fee issues really were her testimony. And I guess ancillary to that was the testimony of Mr. Tabaka, where he confirmed that the fees and the costs reflected in exhibits B and C were in fact paid by him and reflected the work for the show cause. I'll refer to that as the parenting time, the show cause hearings, because we did have 3. So the court would reference that he did confirm that. The court will note that attorney fees are awarded pursuant to MCL 552.13 parens 1, as well as Michigan Court Rule 3.206 parens D. Michigan follows the American rule, which provides that attorney fees are not recoverable unless expressly allowed by statute, court rule, common law exception, or conduct. And that is basically, the court would note the Hanaway case at 208 Mishap 278 1995 case, where the party is entitled to attorney fees where they're forced to incur as a result of the other person's unreasonable conduct. The court is required to have a hearing, which we've had today, and determine if the attorney fees incurred due to the misconduct of the other party are relevant, if you would, or related to, that there's a connection between the fees and the conduct, and are the fees reasonable. And I would cite to Reed versus Reed at 265 Mishap 31, 2005 case. When the court looks at whether the fees were incurred as a result of the other party's conduct, then the court has to engage in the examination, as Mr. Schaefer states. Well, actually, the 9 factors as contained under Smith versus Cowrie at 481 Mish 519, a 2008 case, and I guess it's Pergu versus American Service Auto Association at 499 Mish 269 at 2016. Looking at those factors, the court has to look at the reasonable hourly rate charged in that particular locality. The court, as stated when Exhibit D was admitted in this matter, the court looks at the 2002 Economics of Law Practice Attorney Income and Billing Rate Summary Report provided by the State Bar of Michigan. That report is conducted every 3 years, and so maybe unfortunately for Miss Elaine is that as we know, we're in a period of inflation, so it's likely that those rates could be higher than what they were in 2020. I'm not going to ascribe that. I'm just saying that that is a factor that the court considers as to the reasonableness of those rates, because in 2020, it would probably be that those rates were extremely reasonable. And as we move away from that, and because of the inflation that we've had, and the court notes from, again, other cases in which attorneys have been involved, that obviously fees have increased in the 3 years since this report came out. So, but the court does note in looking at the table 6, reported attorney hourly billing rates by office locality, it doesn't state in there by the locality of where the case is being heard. And especially, as pointed out by Miss Elaine, everything she's done has been in Ingham County. And I guess that's the benefit now of pandemic and video proceedings in this matter is that you don't have to go into a different city, et cetera. But the court does note in doing that, that if we look at family law under that, or in the locality that, again, looking at Ingham County, that under the 75 percentile, it's $345 per hour, up to the 95 percentile of $450 per hour. Then if we go to table 7, the hourly billing rates by field of practice, we look at family law, and in the family law that the 75 percentile is at $300 an hour, and the 95 percentile is at $400 per hour. Court did admit the exhibit A, which is the, I guess you'd say the contract for legal services. It does spell out how Miss Elaine charges in this particular matter. And it specifically, and I'll address that in a little bit as we talk about the emails, because under paragraph 17 of the contract, it does state that those can be grouped and billed at one time per month. Both Mr. Tabaka and Miss Elaine have testified that in fact the emails that have been charged in fact pertain only to the show cause proceeding. Miss Elaine went back with again substantial amount of review, if you would, on her part to review the emails, I guess anticipating that that issue would come up. And she had testified that in November of 2022, there were 50 emails with Mr. Tabaka, only 30 were included. In December of 2022, there were only 3 included. That in January of 2023, there were 42 emails that were included. In February of 2023, there were 237, only 65 of which were included for this action. In March 2023, there were 109, only 42 of which were included. In April of 2023, there were 64, only 28 of which were included. In May of 2023, 102, only of 25 of which were included. And then she shows in June, 119, none of which were included. July, 95, none of which were included. And 236 in August, none of which were included in the billings. Obviously, if we look at that, we have in excess of 400 emails that were not even included in the billings in this particular matter. The court looks at that as to the issue of reasonableness in this particular case when a party does, in fact, leave out and not charge for those particular amounts. Court does find that based upon the survey, the economics of law practice survey, that the hourly rate charged by Miss Elaine of $400 per hour is reasonable in this particular matter. When we look at the hours charged in this particular matter as reflected in defendants exhibit B and C, Mr. Schaefer has in fact called out various charges, but again, as we look at time spent, oftentimes there is some subjectivity to it. But when I reviewed this and I looked at the hours and I looked at for what the, I guess you say the different description of, again, the work that was performed, the court cannot find that there were an unreasonable number of hours expended. Court would note that Mr. Schaefer has not come forward with an expert to identify that, in fact, a number of those hours were unreasonable. And again, Mr. Schaefer does bring up the fact that, as he states, and I'll get into it, in fact, in factor 6 as to the difficulty of the case, he brings up, well, it was a show cause, it was not difficult. But I will state that as the court reviewed my notes in preparation for my finding, the court did find that this was not a very simple, easy, straightforward case. The court had to go through voluminous amount of documents as it relates to the plaintiff's work schedule, correlate that to the missed parenting time, and go over again that. So the court did find that this case presented as a much more difficult case than a straightforward denial of parenting time on, let's say, a particular weekend or a holiday or something of that nature, due to the correlation and the issues involved. So maybe Miss Elaine and myself are both on the same page with that I found it to be more difficult than would be a straightforward show cause proceeding. So when I get back to that, we'll look at the other factor. The way I have them numbered is, of course, first, the reasonable hour rate charged in the locality I've addressed. 2, the reasonable number of hours expended and the difficulty of issues. Number 3, would representation preclude other employment by attorney? Ms. Elaine had testified that yes, as a result of the attention to this case, she's had to, again, to not take other particular cases. She were precluded from other employment. Number 4, the amount involved and the results obtained in this particular case as preparing the case. Again, that's in the discretion and up to the determination of the court, and the parties cannot, again, I guess you'd say, cannot direct, if you would, the results obtained. And there's a lot of reasons that different results are obtained. And again, there were in this particular case. And the court found that Mr. Tabaka was not entitled to all of the hours that he had done, and for various reasons, and those are included in the order in this particular matter. But that is not something that is I guess you'd say, ascribed to either of the parties nor their attorneys in the particular matter, but to the court. And the court would note that, again, the results obtained is, although it was not everything Mr. Tabaka wanted, there was a finding that there had been a denial of the parenting time, and the court ascribed, I think it was, I could be totally wrong, I think it was like 39.5 hours is in the back of my memory, but I don't know specifically, but I think that's what it was. The next factor is the time limitations caused by the client in the case. Again, the client has very little input into this other than the emails, and that the emails would dictate the time limitations in this matter. But the time limitations, as each attorney knows, are governed by the type of the case, the difficulty of the case, the evidence, and all of those other factors that fit into the case. And as I stated, the court finds that there was substantial time limitations in this matter based upon the exhibits, based upon the discovery, because again, it required substantial amount of documents from the Calhoun County Sheriff's Department, required correlation of those to the missed times and that. So the court does look at those particular factors in this matter. Court does look at the difficulty of the case, and as I've stated that already. Length of the relationship with the client. This is the only time that she has represented Mr. Tabaka. So the court's taking all of that into consideration. The next issue that the court does take issue with is Mr. Schaefer's characterization of Miss Elaine's reputation. The next factor is experience, reputation, and ability of the attorney. Miss Elaine had went through all of that. She had graduated magna cum laude, that she was an adjunct professor at Cooley Law School. She worked as a research attorney for the Court of Appeals and then a staff attorney, then gone to a staff attorney position with the Michigan Supreme Court and working for Judge Kavanaugh. I would state, as all attorneys know, you don't get those positions just because you're a so-so average run-of-the-mill attorney. That, in fact, that's a high standard. The court would note as well, has other credentials as well, but she is listed as a top woman's lawyer, that she is listed as a super lawyer in this matter, that she has substantial amount of involvement with Institute of Continuing Legal Education, writing for them, providing videos. That she has provided work for the Family Law Institute. She was a presenter in many subjects, as she states, that she's been a presenter at the Michigan Judges Association, that she had been on the advisory board for ICLE. She'd been on the planning board for a Family Law Institute, that she had authored the property division section of the ICLE booklet, and that she has in fact handled 42 appeals of family-related matters, that she is also, as she stated, that she has been qualified as an expert in an attorney fee case in Ingham County. So the court's taking all of that into consideration and does find that she is very ably qualified and based upon those credentials does have a substantial experience and reputation that the court is taking into consideration. The last issue is whether it's a fixed or a contingent fee. Obviously, that's not applicable, and it's an hourly rate in this matter. When the court does take all of that into consideration, the court does believe that the bill of cost as provided in exhibits B and C is reasonable, and as adjusted by the credit for the transcript, that the amount that would be due and owing by the plaintiff would be the sum of $10,518.20 when I deduct that particular amount. With that, the court will so order that that would be the amount of the attorney fees owed by the plaintiff. With that, I'll ask Ms. Elaine, is there anything else you believe the court has failed to address or needs to address before I conclude?
No, thank you, Your Honor.
Okay, Mr. Schaefer?
I don't believe so, Your Honor.
Okay, thank you. Ms. Elaine, you can prepare the appropriate order, submit those to the court.
Your Honor, actually, there is something. How long does Ms. Tabaka have to pay the fees?
That's already been ruled on.
I won't rule on that. I'm ruling on the amount and the fees. If that became an issue, then it would always be subject to a review by the court at that time.
All right, thank you.
Okay, thank you all, and court will conclude this matter at 3:14 p.m. You're free to go. Have a good day.
I know they emailed an order to me and I told them that they would have to contact the clerk's office in order to get that order entered, and I didn't hear anything back, so
Okay.
I'm not sure. Let me call the case. Calling case 2015-1447 DS, Alexis Tabaka versus Christopher Tabaka. Today is Monday, September 25th, 2023 at 9:47 a.m.
Court will note the appearance of Mr. Schaefer on behalf of plaintiff, Ms. Elaine on behalf of defendant. This matter is before the court on the plaintiff's objection to the defendant's order. Mr. Schaefer.
Please the court, Your Honor. There are a number of orders out. I think all of them got agreed to except for this one, and that the only objection that was filed was in relation to two words under paragraph 2. That reads, the provision does not apply to periods of 1 hour or less, and defendant's wordage is before school. We're objecting before school. That's the only objection that we have. I think by excluding that, it encompasses that which was discussed, argued, and ruled upon by your honor, that it made no sense to have somebody drive a half hour one way, that there was an hour time period, no matter if it was in the morning, before school, or in the afternoon. So I think it's consistent with the ruling of the court to exclude the two words before school.
Okay. Ms. Elaine, I know we went through this before. That was my understanding, is we were going to state that, you know, if it's an hour or less, I don't believe that we talked about, you know, including the language before school.
We did, Your Honor. In fact, this was the exact objection Mr. Schaefer made at the September 11th hearing and the June 26th hearing. This is like Groundhog Day. This court rejected that language at the last hearing, which was, well, both hearings, it rejected that language. So this is the third time we've been before this court with this particular language at issue. I've got a transcript from the June 26th hearing to read to you, and I've got the YouTube section of your ruling to play for you from the September 11th hearing. This court ordered that because there is only a transportation weirdness that occurs in the morning, it would not interpret the parenting time provision to apply to periods of time where Alexis could only produce the children for an hour or less. However, in the afternoon, that transportation problem does not exist. Mr. Schaefer just doesn't like the ruling of this court. Alexis Tabaka does not like the ruling of this court because she is engaged in a battle to thwart parenting time that Dr. Tabaka is entitled to have. It is egregious to me that we're here on this again. And what the court ordered in June 26th is the following, and this occurs on page 17 of the transcript. Court says, if she's working at the office and the kids need to be picked up from school, taken to piano, whatever it might be, he has the right to do that until such time as she gets home from the office. Mr. Schaefer said, so if she comes home from the office to pick up the kids, then she would be able to pick up the kids. Court said, yes, correct. The court said, I don't want it to apply. Well, grandmother, aunt, uncle, neighbor, or that type of thing would be picking up the kids. It should be with the parents. And if it can't be with the plaintiff, then they should be with the defendant. This is in the midst of arguing about this time parameter and where that should apply. And the court was saying that it has to apply in the morning because of the transportation from Battle Creek to Marshall. But because the kids are in Marshall schools and the father lives right there, there is no time limit on the afternoon, because what that would mean is if she weren't available for a half hour in the afternoon, other people, grandmothers, aunts, uncles, neighbors, or most recently, Alexis's tenant will pick up the children after school for 15 minutes or 30 minutes and divest Dr. Tabaka of that parenting time.
Okay, clarify for me if you can. I don't understand. I guess I'm missing something. Is that
okay?
The hour, Mr. Schaefer says, should not include where it says just before school. And I'd already ruled that on the September 11th date that hour provision wouldn't pertain to after school.
Right. But he
So-
wants it to pertain to after school. Mr. Schaefer is arguing that if she is not available from the time they get out of school for an hour, then Dr. Tabaka can't go pick them up, which is directly contrary to the whole point of what this court ruled.
Okay, well, that was my understanding of the way I ruled on September 11th. And we addressed that specifically. So the
And
hour
Mr. Schaefer's
provision-
order was rejected. Sorry, Your Honor, I
the
didn't mean to
hour
interrupt.
provision would not pertain to after school.
Correct.
So
Right.
I guess
And
from that standpoint, Mr. Schaefer, I guess I would deny your objection. Because I'd already ruled on that on the 11th. So
Well, there's a lot of rulings.
I know. That's
Wasn't
why it was a little bit
crystal clear.
confusing.
Yeah, and the problem is that we're dealing with a 2016 that the words are being parsed and being applied inappropriately. So I think what I had suggested was consistent with your overall ruling. We'll live with whatever Your Honor believes that he ruled, but I think
I'll stay with what Ms. Elaine had said, that the hour would only be before the school, and that
Yeah.
any time after that, as the court ruled on September 11th, it would be that he has a right and he wouldn't be limited by that hour provision.
Your Honor, I would ask for attorney fees. This was explicitly clear on September 11th, and Mr. Schaefer's language that he submitted for this purpose today was the same as the one the court rejected on September 11th. I emailed him immediately after he filed this objection. This is the third time we've been to court on this particular order, and pointed him to the place in the YouTube where you made your ruling. He just didn't respond to that email, and we're here. I would ask that he pay my attorney fees for an hour of time for $400.
Okay, well, go ahead, Mr. Schaefer.
Your Honor, again, it wasn't clear. Your Honor is struggling through it. I struggled through it. I went and reviewed it, and I am not clear that it was before school. And it certainly is a legitimate matter to bring back in front of the court. I don't think the attorney fee is valid at all, and I'd object to that.
Okay. Well, the court's not going to grant the attorney fees at this point. I can understand how there may be some confusion, but obviously it does appear that, I addressed this matter back on September 11th, but I'm not going to award the attorney fees at this time, but if we continue to labor at this issue, that would be appropriate. So, Ms. Elaine, do we have your order?
Yes, Your Honor, I did email it to Ms. Woodward this morning. I would ask, please, if we could prevail on you to sign that from the bench so we don't have a fourth objection.
No, that's fine. I'll get it filed. I'll get it signed today.
Thank you. Okay.
Okay.
Thank you, Your
Thank
Honor.
you.
I appreciate it.
Court will end this matter at 9:54 a.m. You're free to go. Have a good day.
Thank you.
Thank you.
Okay, Judge, I am bringing in the Lindsay Arzola case. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2015-1447 Alexis Tabaka versus Christopher Tabaka. Today is Monday, October 2nd, 2023 at 9:01 a.m.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Elaine on behalf of the defendant. This matter is before the court on the defendant's motion to set aside the referee recommendation of September 12, 2023 pertaining to the discovery subpoena in this particular matter. Ms. Elaine, you can proceed.
Good morning, Your Honor. Thank you so much. Your Honor, I know that you've read what's been submitted regarding this matter, and I guess I would first note that there wasn't much of a defense coming from Alexis's side with regard to the legal issues involved in the wide-reaching, based on conjecture subpoena that was issued with regard to my client's entire cell phone records. I guess the whole premise of it needs to be focused in, and that is that it is based on conjecture. There is so much conjecture. Actually, there's not a lot of conjecture. There's just conjecture on 2 points, but it is pure conjecture on which this subpoena was after the fact justified on. And one of the suppositions, as I call them in my brief, that was made by Alexis, I think is so far-fetched that it wasn't even defended in the response to our brief. And that had to do with whether Mr. Tabaka has called therapists on behalf of the minor children. I mean, that was just literally made up that day. There's been no indication that that's happened. There's been no claim, there's been no allegation, and there's been nothing flowing from any sort of claim that he has called a therapist. So I think based on the response to our filing, that is now a non-issue. The other one is this claim that Dr. Tabaka goes to property that he owns to harass Alexis. And again, that wasn't pled. It hasn't been raised. I deposed Alexis for 7 hours. She did not raise that particular claim that he is using his phone to somehow plan to go to his property to harass her. And I would say, too, that if Dr. Tabaka is harassing Ms. Tabaka, there are facts that will show that. It's not his phone records that will prove harassment of her. It is things that he is doing. So if she wants to claim that he's coming to his property and peering over a fence or hiding behind a tree, I mean, she can certainly do that and the court can take that for what it is, but the phone records don't show that sort of claim. You know, discovery rules in Michigan also offer protection at the same time as allowing parties to flesh out their case. The flip side of discovery rules is they offer protection to the party about whom discovery is sought. Obtaining someone's phone records, and because this court handles so many family law matters, along with all sorts of other matters, I assume this court feels the nightmare that would come on if every litigant in a family law case were able to subpoena and discover the other party's entire phone record. It's literally just unheard of. I haven't seen a request this broad in any of my cases in the years that I've been litigating family law cases. It's so excessive, it's so abusive, it's so overbroad, and it's a complete and total invasion of
Your Honor, she is frozen up. I can't hear
Yes, she
her.
has. We'll have to wait until it unfreezes. You're back with us now, Miss Elaine.
Okay, I'm not sure what happened. I just left and now here I am.
Yes.
But it is a complete and total invasion of Dr. Tabaka's privacy. And I don't think it is a precedent that any court would want to set in litigation that any party, because if it is granted based on the reasons that it has been requested, then I think what flows from that is any party in any case would have the right to discover the other person's entire cell phone record. And I don't think that's at all what is intended by the discovery rules. In fact, I think that they mitigate quite stringently against such an overreach. And I think that Alexis has completely failed to draw any factual connection between what she seeks and the way that she is seeking it, be it his cell phone records. I guess I don't know what else to say, Your Honor. It's a little bit shocking that the request has been made, and I would hope that this court see through what is trying to be done and deny the request to obtain Dr. Tabaka's entire cell phone record.
Okay, thank you. Mr. Schaefer, I note that Ms. Elaine in her motion does set forth saying that much of what you're requesting as it relates to the kids is on the kids' phone records that your client has or can get. So what is it that you're seeking from the plaintiff, from the defendant, that you believe is relevant and I guess appropriate for discovery in this matter?
Okay, and I will address that, Your Honor. First of all, discovery is broad. Our position has been that historically, Mr. Tabaka has been a harassing factor in the life of my client and of these children. And I only requested since May of 22. I didn't go back to 2016, which there is a history. And the interesting thing is we've been trying this for 2 or 3 days, and it's all been Mr. Tabaka's testimony basically up to this point in time. There is allegations and proofs that are going to be put out there that this is a concerted effort on the part of Mr. Tabaka to bury my client financially and overwhelmingly, as admitted. Her deposition on irrelevant things took place for 7 hours. Her significant other was testify under deposition for 4 hours on irrelevant things. So there is a history of harassment. I anticipate that his records will show statements of his intent, of what he is doing in this regard, of his in constant contact with the children at the times when they are in the custody of my client at her property. I anticipate there will be testimony between Mr. Tabaka and school officials and other people indicating when he is going to contact them, what he is going to do, and so forth, which is all going to be supportive of our position of the harassment that Mrs. Tabaka is going through. The subpoena was tempered by the referee, and that none of the attorney-client numbers were going to be part of that. What is a little disconcerting is this subpoena was in May of this year, some 4 months ago, and inappropriately, I suggest, that it was blocked by defendant's counsel by sending them at least a indication of representation that a motion to quash was being filed and heard. As indicated in our answer, the emails that I got back from T-Mobile when I followed up with why you haven't complied with the subpoena was that they were very vehement that there was a motion to quash that subpoena, and they were not going to do anything until that June 26th date went around. And as it was learned later, there was no motion ever to quash. So I'm not sure what that was all about, but certainly it was inappropriate to do that without filing a motion. So we're here 4 months later. We are about the third day into the hearing, and I don't have access to those records to cross-examine the defendant in this particular matter. And I think it's a legitimate discovery. I mean, discovery is broad. If he's got specific things that he thinks that are not appropriate, I think they can be ferreted out. But I don't think that a quashing of this subpoena is appropriate. It is discoverable items. I anticipate, I hear the argument, well, it's a fishing expedition. It's conjecture. Well, it's not. It is following up and trying to do discovery on elements that we believe are there, that there's a history of ongoing for many years. And I think we need that for cross-examination.
Well, Mr. Schaefer, you stated that one of the things is, again, or the basis of it is for this harassment claim, and you say, well, the repeated calls to the children, your client has access to that. It's on her phone bill with the children.
It's not, she doesn't have that, Your Honor.
Okay. And why isn't it? Doesn't she provide the phone, or is it the defendant that provides the phone for the kids?
Well, I believe it's the defendant's providing the phone.
Okay.
As I recall that part of it. And this
Hold
was.
on, I think we lost Miss Elaine again. Hold on.
Judge Kirkham.
Yes. You're back. You can hear us fine.
Judge Kirkham, I've missed so much. Apparently my internet connection is terrible. I'm in another courthouse. May I call in by phone to see if that's any
Sure.
better, because I missed half of the argument.
Sure. You have the phone number?
No, but
Okay, give it to her, please.
okay, thank you. I'll call right in.
Hear us?
Yes, thank you.
Miss Elaine, where did you, I had asked Mr. Schaefer about the children's phones, and he's stating that again, the phones are through your client, so she doesn't have access to, again, the amount of phone calls made to the children. Is that accurate? Elaine, where did you
Oops,
I asked
sorry.
Mr. Schaefer about the.
Your Honor, a couple things with regard to the children's phones. First of all, there was a subpoena issued for the children's phone records as well. And during the hearing with the referee, we waived any objection to that subpoena. So that subpoena is being executed as we speak. And so Mr. Schaefer and Ms. Tabaka will have the entire phone records of the children.
Okay.
And
Mr.
second.
Hold on,
Sure.
Miss Elaine, hold on. Mr. Schaefer, you're gonna get those records then, doesn't that take care of that issue?
I don't know if I'm going to get the records or not. I haven't gotten them yet. I've submitted them and there's T-Mobile is still communicating with me that there's problems going on and I don't know exactly what the problems are. But the thing is that I don't think I'm prohibited just from one source. And there are other reasons.
Well, Mr.
that
Schaefer,
I need-
I'll tell you, just so you know, I'm not gonna allow you to go in and get everything that Mr. Tabaka has on his phone records because of this particular claim. If it's relevant to the claim, I'll let that, you discover that, but if it isn't, then I'm not gonna just simply let you and open up all of his records under the guise that, oh, it's somehow relevant or discoverable or material. I mean, I want to have some connection before I'm going to allow that.
Well, the connection, Your Honor, is what I argued before, is that this has been an ongoing harassment on Mr. Tabaka's part, that I anticipate that his phone records are going to verify that with third parties. And so I think that is certainly relevant to the issues here.
But
And
you
it's a-
mentioned specifically the calls to the children.
That's
And
one of them. That's one of them.
As one, you said there were some issues concerning school officials. Couldn't they testify that he's called and harassed them?
There will be some that will be subpoenaed who will come in, but I certainly think it is relevant and very material that we have the phone calls that he in fact made and the records of those to whom he made of the school officials.
Your Honor, this is a fishing expedition. I mean, I think it's becoming crystallized even more than it was for me before. It's just a fishing expedition. This is the first mention now of school officials. So
Yeah.
that wasn't mentioned at the hearing and it wasn't mentioned in the brief. I mean, he's just pulling things out of the air to try to draw some thread
Your
where
Honor,
none exists.
this is no different than any other discovery. 7 hours, my client was asked of things that went on for years and years, many of which
Okay.
was irrelevant.
Quite frankly, I don't care how long the deposition is. It's not germane to this subpoena. So unless you can tie it up to the subpoena, the court's not really interested in it.
Okay, very good. Then I submit that there are relevant issues as to his contact with school officials, his contact with third persons, as to his activities, as to when they did his harassment efforts against the plaintiff and the children.
Okay, well, I think that's obviously overly broad. I've already stated that you're able to acquire the contacts and communications between him and the children to do that. I don't know that as it relates to the issue of the school, I don't know how that's germane to the issues before the court of the referee. If there's a harassment claim or you're looking after a personal protective order, it would be germane at that point, but I don't think it is at this point. So the court will
May I address that last issue, Your Honor, before you rule?
go ahead.
There is going to be testimony that there was a counselor at school that Mr. Tabaka contacted and threatened to sue because the counselor had made allegations that the child had said that he was physically abused by Mr. Tabaka. And as a result of that threat of a lawsuit in relation to this counselor changed positions. And so that certainly is relevant to the harassment that has been ongoing and the intimidation in relation to the school officials. So that's certainly something that is specifically going to be in his, reasonably in his phone record.
Your Honor.
You-
it-
Yeah, hold
if
on, Mr. Schaefer, do you have a phone number of that counselor? So,
At the moment, I do not.
okay, well, what I'm gonna do in this matter, I am gonna allow, again, the subpoena to the extent that, and we'll put the numbers in it, to the extent of his contacts with the children at their particular phone numbers. And Mr. Schaefer, if you get the phone number for this particular school counselor, we can put that in the order as well and say that that it is discoverable as it relates to that communication between the defendant and that phone number. But that's the extent of it. Otherwise, I am going to quash generally the subpoena, except with those conditions. Ms. Elaine, you can prepare the order, and then Mr. Schaefer can get you that phone number of the counselor. And again, those items would be discoverable.
Okay, thank you, Your Honor.
Okay, thank you. And you can submit that under 7-day, obviously, provided Mr. Schaefer gets you that number. Mr. Schaefer, I'd have you get her that number by the end of the week so she can comply with the 7-day notice.
I will, if possible, Your Honor. It's been some time ago, so I'll make it real.
Okay, thank you. That will conclude this matter. Have a good day.
Thank you, Your Honor.
Thank you. Bye-bye.
All right, Attorney Schaefer, I'm gonna put check. Attorney Schaefer, do you know if Alexis plans on appearing this morning?
I do. She's in my office.
All right. Calling King, the 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. Calling case 2015-1447 DS, Alexis Tabaka versus Christopher Tabaka. Today is Monday, November 20th, 2023 at 9:03 a.m.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Elaine on behalf of the defendant. This matter is before the court on the plaintiff's motion for attorney fees. I do note that we do have, I have reviewed the motion as well as the answer in this matter. Based upon that answer, it does appear that we would need an evidentiary hearing in this matter. And I do note that we do have an evidentiary hearing scheduled as it relates to another matter. So, Mr. Schaefer, do you have any opposition to just putting this matter over to that and addressing that at the evidentiary hearing as well?
I think that probably makes sense. I anticipated the court would set up an evidentiary hearing.
Okay, Ms. Elaine, does that sound reasonable to do to you?
Well, Your Honor, I think there's grounds to just dismiss the motion without an evidentiary hearing based on the deficiency of even alleged facts in the motion and the fact that Ms. Tabaka has demonstrably misled the court with regard to certain critical facts. So I think an evidentiary hearing would be inefficient for this court, but also cause an expenditure of attorney fees that Alexis is complaining about that is again going to be another self-inflicted wound and cause Dr. Tabaka attorney fees that he should not otherwise have to pay.
Well, and looking at this case, it does look like it's rife with self-inflicted wounds. So I think it's a death by 1,000 cuts. So what we're going to do is, I do believe it's premature to address the attorney fees till I've heard the case in this matter. So the court's going to simply reserve on that, and we'll wrap it into the evidentiary hearing that we already have, and we can address the matter there. Just, Ms. Elaine, I do note, based upon your answer, there's some factual issues that need to be addressed, which I'll want to address before I would make a determination in that matter. So we will reserve it until that particular hearing.
Your Honor, excuse me, there are a number of hearings that are pending. Could you give me the date of the hearing that Your Honor is referring to?
I'll have Ms. Woodard to look it up.
Yep, I will check. It is scheduled for, looks like January 18th at 1:30.
Okay, very good. Thank you.
Okay, we will see you all back then.
Your Honor, May I ask a procedural question, please? On
Sure.
that date, that's set for an evidentiary hearing on a show cause motion that this court scheduled. Would we go first on the show cause? And then just so that
Yeah.
I know how to prepare for that
Sure,
hearing.
we'll let you go first, as
Okay.
your motion was first, and then we'll
Okay.
proceed.
All right,
Okay.
thank you, Your Honor.
Thank you. Court will end
Thank
this
you.
matter at 9:06 a.m. You're free to go. Have a good day.
Thank
Okay,
you.
thank you.
Judge, or, I'm sorry. Tom, is your client with you?
She is.
All right, calling case 2015-1447 DS, Alexis Tabaka versus Christopher Tabaka. Today is Monday, December 18th, 2023 at 9:01 a.m.
Good morning to everyone.
Good morning.
Good morning.
Court will note the appearance of Mr. Schaefer on behalf of the plaintiff, Ms. Elaine on behalf of the defendant. The matter is before the court on the plaintiff's motion to show cause. I note in reviewing the answer, Mr. Schaefer, that Ms. Elaine had stated that in fact that the arrearage in this case had been paid off. Have you were able to confirm that?
It was paid off as of November 24th. We confirmed that it got paid off on that particular date.
Okay, so that's a moot point at this time.
I think so, Your Honor, yes.
Okay. What we'll do in this matter, I do note as well that Ms. Elaine had brought up the issue of the counseling, and again, that had happened years ago in this particular matter. It's my understanding that that may be a moot point as well. Have there been any new attempts at counseling since this court was involved, Mr. Schaefer?
I don't believe so, Your Honor. There have not been, there's a tortured history of that back when, and we have gone back on so many different things on support and parenting time, and we still have parenting time and custody pending and another show cause in relation to the parenting time. And this was all amalgamated together back when, and during the testimony, it is clear that, and admittedly so, that there was a violation of the order of joint custody, and that is why we are bringing it at this point in time, just because it's an ongoing, from our perspective, an ongoing harassment that needs to be held in check, and I think it needs to be reviewed.
Well, this court had obviously had a hearing in this matter, quite extensive hearing that we concluded with an order of September 25, 2023. I will let the parties know I'm not going to go into any other matters that predate that order of September 25, 2023. So if in fact the court would allow a evidentiary hearing, because we have a lot of other claims I guess floating around, but I'm not going to go back prior to the September 25, 2023. So I'm only going to take up matters at an evidentiary hearing that post date that particular order. So we will contact both of you and see when you're available and when we can set up hearing to resolve the other, I guess, pending claims in this matter. But so both of you know, I'm not going back to anything prior to that September 25 order.
Your Honor, to my knowledge, there aren't any other pending matters that aren't currently scheduled. Do you have a different understanding?
No, I just know that we've had so many motions filed and so many other things. I just want to make clear that I'm not going to go back prior to that date. So if that resolves everything else that we have, then we won't need an evidentiary hearing. So, but I'll leave that up to the two of you.
I think that's a fair analysis. I think everything else is scheduled, Your Honor.
Okay.
Your Honor, if I may, especially based on opposing counsel's responses to your questions today, I do think this is appropriate for an attorney fee award for the reasons stated in our motion. I think it can't be more clear that Ms. Tabaka is doing this as a retaliatory measure. And Mr. Schaefer today is not offering any legal argument to support the allegations that were brought. And I do think the court should put a stop to that and send a message that it's not going to entertain its judicial position to hear retaliatory motions brought years after an alleged event occurred.
Well, I don't know.
Right. I'll be
Fair
happy
enough.
to respond, Your Honor. There's
Go
a
ahead.
lot more to this, and I'll be happy to, but based on your ruling, I think it should be done at this point in time, but I'll be happy to deal with the retaliatory question as it relates to the other side.
Okay, well, what happens is, why don't we do this, is it appears that there are no outstanding disputes in this matter, other than, as Ms. Elaine brings up, the attorney fee issue. So what we'll do is I will, I guess, leave it open that any of the parties, if they have anything that post dates the September 25, 23 order, they can file a motion, and then we'll take that up at that time and have an evidentiary hearing if we need. But I guess I'll put this matter to rest at this point. Okay,
Thank you, Your Honor.
thank you.
Thank you.
Thank you all. We'll end this matter at 9:06 a.m. You're free to go. Have a good day.
You too, Judge.
You too, sir.
The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2015-1447 DS, Alexis Tabaka versus Christopher Tabaka. Today is Monday, February 12th, 2024 at 10:02 a.m.
Court will note the appearance of Mr. Schaefer on behalf of plaintiff, Mr. Lohr in place of Ms. Elaine on behalf of the defendant. This matter is before the court on the plaintiff's motion to withdraw, for Mr. Schaefer to withdraw as counsel in this matter. Court does note that I've reviewed the answer as well. Mr. Lohr and Ms. Elaine state she has no objection to the withdrawal. Is that accurate?
That's accurate. We would just, like to have the hearings that are currently scheduled proceed as scheduled.
Well, Mr. Schaefer, looks like there's no opposition to your motion.
Yes, it's an awkward situation, Your Honor. It's just gotten to a point that my client has requested that I file this motion. And I've explained to her what her obligations are going to be, and it's going to be difficult, but that is her request, and it's my request. She is completely tapped out financially, so I would respectfully ask that to be granted.
Okay. Court will grant the motion while we withdraw in this matter. Mr. Schaefer, have you filed an order on this or not?
I'm not, but I will put it under the 7-day.
Okay, thank you. I'll conclude this matter at 10:03 a.m. You're free to go. Have a good day.
Okay, thank you.
Thank you.
37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2015-1447 DS, Alexis Tabaka versus Christopher Tabaka. Today is Monday, March 18, 2024 at 10 a.m.
Court will note the appearance of Ms. Elaine on behalf of the defendant, the plaintiff appearing in pro per. In this matter, the plaintiff has filed a motion to show cause for violation, as she states, violation of the order of November 3rd, 2015 and September 25, 2023. The defendant has filed a very thorough answer in this matter, disputing the allegations in the motion to show cause. As a result of the dispute, the court is going to have an evidentiary hearing in this matter. The court notes that we have a hearing scheduled for April 9, 2024, and the court would intend to put this matter on at the same date so we can hear all the matters at one time and hopefully avoid some of the expense to the various parties. Anything else, Ms. Tabaka?
No, Your Honor, that sounds good. Thank you.
Okay, Ms. Elaine, anything?
Yes, Your Honor. I would urge this court to consider the underpinning of what is going on here, and that is that Ms. Tabaka will do anything right now to get this court to hold Chris in contempt for anything that he does. She is trying to get a hash mark on her side of the scorecard because she somehow thinks that if she can get this court to hold Chris in contempt, that will somehow mitigate or erase the 3 contempt charges this court has issued against her. And it's critical to note that every time Chris has brought a legitimate show cause Ms. Tabaka responds with a frivolous one. And I would urge this court to impose a standard here that just filing a motion to show cause does not entitle one to an evidentiary hearing, but that the allegations need to be looked at. And even if her allegations are taken as true, she hasn't pointed to any violation in the court order. If this court entertains show cause motions because one parent didn't notify the other parent that the kid had the sniffles as fast as they could, then everyone on YouTube is going to be flooding this court with meritless and frivolous show cause motions to try to get the other parent in trouble. And I don't think that that is what this court wants. And I don't think that that is the purpose of the judiciary and the judicial proceedings that are available to us. But that at its core is what is going on here. If Ms. Tabaka has a complaint that the kids weren't really sick, then that is something for the custody hearing that we have going on. If she has a complaint that he took them out of school for a trip, then that is a complaint she can lodge during the custody proceeding because there's no court order that prevents him from taking them out of school for a trip. If the complaint is that they weren't sick enough to keep them home, then that again is something that she can allege and assert in the custody hearing. This at its core is a complaint that she is dissatisfied with co-parenting, of course, based on her motivation to just get him in trouble. But be assured there's a lot of dissatisfaction with the co-parenting going around both ways in this case. And if every parent dissatisfied with the other parent's style of co-parenting is going to file a show cause, again, this court is going to endure a tsunami of illegitimate and meritless complaints. And for that reason, I urge the court to see this show cause for what it is, which is meritless, baseless, frivolous, and deny Alexis's opportunity to have any further proceedings on this.
Okay. Well, as Carter originally stated, there is a dispute in this particular matter. And it's stated, what's going on and the action's frivolous. I can't make a determination of that until I've heard the basis for the again, determination. So the court will wrap that into the April 9th hearing, and we can address it at that time. The court can determine whether there's any merit or a frivolous claim at that time. So that will be the finding as it relates to this motion. And you're free to go. Have a good day.
Thank you, Your Honor.